Hi, everyone. My name is Miriam Lacroix, immigration attorney and founder of Lacroix Law PC, where we give immigrants peace of mind while helping them navigate their path to legal status. And so today's video, I really wanted to talk more about the marriage-based green card process and three common mistakes that I see time and time again that I want you to avoid. So let's just jump right into this. The first mistake is applying for your permanent residence too soon after you enter the United States on a non-immigrant visa. So let's talk about the 90-day rule real quick. So the 90-day rule is something that USCIS uses as a way to determine what someone's intent was when they entered the United States on a non-immigrant visa. So what the rule says basically is that if you enter the United States on a non-immigrant visa, right, maybe a visitor visa, and you do a certain list of things within 90 days of entering the United States on that visa, you could be considered inadmissible. Filing an application for permanent residency or your green card is one of the things on the list that could make you inadmissible if you apply too soon after entering on your non-immigrant visa. Non-immigrant visas are supposed to be temporary for a temporary stay, temporary visit. And so if you get married within 90 days of entering the United States on your visitor visa, which is a non-immigrant visa, USCIS will automatically assume that you may have had other intentions other than coming to the United States just to visit or for a temporary stay. They may likely assume that you had every intention to apply for your permanent residency when you came, and that would be a ground of inadmissibility. And that is something that you just don't want, right? It is possible that you won't get denied, right? It doesn't necessarily mean that you will be denied because you got married or applied for your green card within those 90 days. But this is something to talk with an immigration attorney about because you are likely going to have to prove that you didn't misrepresent your intent when you came into the United States on a temporary visa. And temporary visas like visitor visas or student visas, right? Those are for temporary stay. But if you enter on a temporary visa and decide to stay permanently, and you do that within the first 90 days, it is likely you will have to prove that your intention was never to stay permanently when you first entered, but maybe that it changed. That might be something that could be a little difficult. So speak with an immigration attorney before you go ahead and do that on your own. Another common mistake is your sponsor not making enough money to sponsor you. So there's a difference between your petitioner and your sponsor. Your petitioner is the family member that's asking for you to join them in the US and for you to obtain your permanent residency. Your sponsor is the person who promises the US government that you will be taken care of financially and that you won't be on public assistance or anything like that, right? You're showing that you have financial resources when you enter the United States so that you aren't dependent on public benefits. Your petitioner is always your sponsor, right? That's your first sponsor. But if the petitioner doesn't make enough money, then you might need a joint sponsor. Along with their petition, your petitioner fills out an affidavit of support, and they have to show that they make enough money to support you, themselves, and any other person they're responsible for with their income. And so let me show you the income requirements. So according to the USCIS.gov website, these are the income requirements for a petitioner or sponsor to bring a beneficiary or sponsor a beneficiary in the United States, right? So if it's just your spouse and you, if your spouse makes at least $21,775, then they make enough to sponsor you, right? You won't need a joint sponsor. You should have enough money to prove that you won't be what's called a public charge in the United States. If you come very close to this number, sometimes attorneys recommend that you get a joint sponsor. But if you're well over this amount or a little bit over this amount, that would be good for your application. However, if your spouse who is petitioning for you also has children or a parent or anyone else who they are financially responsible for, those people also have to count in those numbers. Okay. So if your spouse has a child and you have a child, that's 4 people. And so you would have to show that, or your spouse or petitioner, AKA sponsor, would have to show that they make at least $33,125 to petition for you and to be the only sponsor. Now, if finances is an issue in your situation, you definitely want to seek the advice of an immigration attorney to determine if you need a joint sponsor. Maybe you have certain assets that will count if your income is below the income mark. So speak with an attorney and see what your options are. Finally, another pretty big mistake that some people make when applying for their marriage-based green card is applying when they aren't even eligible. And that's huge because if you get denied, it's possible that you can be placed in removal proceedings. And so you want to make sure at the very least that this is something you're eligible for. The other things, you may receive a request for more evidence from the US Citizenship and Immigration Services to explain yourself, to explain your income, to explain your intent. But if you're ineligible, then you are simply ineligible, and that will lead to a denial. So there are certain bars to adjusting your status or obtaining your green card in the United States. The first one is entry without inspection. So if you enter the United States without inspection, meaning that you didn't enter with a visa or some other lawful way of entering the US, it's possible that you won't be able to adjust your status. You may have to leave the country in order to get your green card. And so in that situation, you won't be eligible to adjust your status in the United States through the marriage-based green card process. There are other processes for you to get your green card through your spouse, but you won't be able to adjust your status. And when I say adjust your status, I'm saying filing the petition and the green card and the work authorization, all those applications at once. That is something that only certain people get to do. But if you entered without inspection, you will not be able to do that. You will have to stop after the petition portion of your case and get a waiver for the way you entered, and then attend a consular interview once your waiver is approved. So the process is going to be very different, okay? So one thing to keep in mind in terms of eligibility for your green card is how you entered the United States, because that will change the process, not you actually getting your green card. You can still get your green card, but it will change the process for you and it won't be as straightforward. Another way that you can be ineligible for your green card is certain serious crimes or admission to committing serious crimes that you weren't actually arrested for, right? And so you have to be very careful with those things. If you have a criminal history, if you have a history with alcoholism or drugs or anything like that, those things could affect you moving forward. And the history with drugs or alcohol doesn't necessarily mean that you have to be convicted of crimes related to those things, right? You can still be considered inadmissible. So make sure that you speak with a trusted immigration attorney if you do have a criminal history. Another example of something that might make you ineligible to adjust your status through your spouse is if you enter the United States as a fiance. And not the fiance of your current spouse, but the fiance of a different spouse or potential spouse, right? And this is something I see often is I might consult with someone who entered the United States years ago after the petition of a previous fiance. And then when they got to the US, it didn't work. They never got married or they never filed their green card application. And now they've fallen in love, they met someone else and they want that spouse to petition for them. That is not going to be able to happen unless you fall under an exception, right? And so you want to be careful of submitting a green card application if you fall under one of these ineligibility criteria. You may not know exactly how you may be eligible for something or when you may be eligible for it. And so the best way to make sure that you are filing the right applications, that you're going through the right process, and that you are successful is to speak with an attorney so that they can hear about your particular circumstance and advise you based on that. So I hope you found today's video helpful when it comes to your marriage-based green card process. I do marriage-based green card cases and I love doing them. I've done some with some of these complicated factors and some other ones that are a little bit more straightforward. But if you're going through the process, definitely reach out to me, schedule a consultation so that I can figure out what options are best for you.